Hey everyone, it's Vlad Portnoy. It's Tuesday, and that means we're doing our regular session on questions and answers on all things estate planning. As always, we welcome your questions that we can hopefully address, and make sure you do ask them because chances are, if you have them, someone else does too. And here we go. Special needs trust is a form of a trust. Now, what's a trust? A trust is a legal document. It's an agreement between a grantor and a trustee that is set for the benefit of some kind of a third party, the beneficiary. A special needs trust is a trust set up by a grantor for the benefit of someone, the beneficiary, who is on public benefits. There are two types of special needs trusts. They're both called S&T, special needs trust, or supplemental needs trust. They're both S&T and sometimes they're interchangeable. There is a first party trust and a third party trust. Now, this sounds a lot like legalese because it is, but hear me out. It's actually quite simple. A first party trust is a trust, is an S&T that is set up by a person for their own benefit. For example, a young adult has Medicaid and that is their lifeline. They cannot lose it, but they also won a lawsuit or received a side. So, for example, a young adult that is receiving public benefits like Medicaid or SSI recently won a lawsuit that may be underlining their entire disability, or maybe they were disabled from birth, and they cannot jeopardize their benefits, but they cannot also not accept the funds. One, it would be a waste, and two, Medicaid and other programs would consider it fraudulent in order so that the person is refusing the funds so they can stay on the program. In a first party trust, a person sets up the trust for themselves and funds it with their own funds. If the person is a child, their parent or guardian or several other types of people can set this up for them. And usually in an everyday structure, if it's a child, their parent would be the trustee of this trust. This way, all the funds are poured into the trust and reported to Medicaid and other programs, but the funds are considered not available to these programs for recovery. A third party trust is a trust that is set up for the benefit of that kind of person with disability, but by a third party, for example, their parents, grandparents, or someone else. So if the parents have investment accounts and they would like to leave those to their child for the child support when parents are no longer able to support the child or passed away, the funds would be available and the successor trustee would be designated in the same trust. There's a nuance where a third party trust is just what it is. Funds would be available to the disabled individual while they're alive. And if there's anything left, the funds will be distributed from the trust to the next of kin or whatever the trust designates. With the first party trust, because it's the person's own funds, there is what's called a Medicaid payback provision where Medicaid gets paid from the remaining funds after the death of the individual to the extent that the funds are available, and Medicaid has a lien. Special needs planning, of course, helps because special needs planning is the term of art is to supplement and not to supplant, meaning that these funds are available for support where all other programs are not providing payments. But because these funds are deposited into a separate legal entity like a trust, the funds are not considered available. And so the other programs like Medicaid may continue providing assistance. You absolutely need a lawyer who handles special needs planning. The idea is that, first of all, you need a specialist in every direction. If you are in trouble with the law, you're going to go to criminal defense attorney and you're not going to go to a personal injury attorney because they're just an attorney. It's the same thing as going to a sushi restaurant and asking to fry you a steak. They're chefs too, they're amazing, but it's not what they do. So you absolutely need a specialist in general to create a trust. So it should be a lawyer and it should be a lawyer specializing in this not someone using a cookie cutter template they poached from their grandfather from 1968. And that lawyer also has to be not only an estate lawyer, but also what's called an elder lawyer or special needs lawyer who can actually address all of the concerns and knows all the nuances of the S&T, special needs trust. Idea of special needs trust addresses exactly this problem. Usually, when the parents are young, relatively young, middle aged, and the child is underage or young adult, there's no problem. Parents just try to get as much work as possible on themselves. Sometimes they work 2 or 3 jobs, and they earn enough money to support themselves and the child. As the time progresses, the parents will age and so will the child. So if the parents are 30 and the child is 10, not a problem. But if the parents are 80 and the child is 60, we have an issue. And so the special needs trusts are the prime vehicle to resolve this. However, it must be noted that the trust itself is only a vehicle to carry other assets. So careful planning must be done with your tax and financial professionals. We always work with CPAs, with accountants specializing in trust and estates taxation, and financial planners who can also advise on taxation and help create more wealth. For example, one of the key elements to put into a third-party trust, especially, is the life insurance. When the parents pay for life insurance, but it's owned by a trust, upon their death, it's not in their estate, and there would be a substantial amount of money that the successor trustee can take over and provide for the child. That should be a no-brainer.